once again, I'm Joel Cohn. I'm Legislative Director for the Office of the Tenant Advocate, and welcome to What's in the Hopper Rental Housing Hot Topics at the DC Council, Part 2. This is going to, I'm told we have to leave at 4:30, so we have a short, abbreviated session this time. It's going to be an hour, and fortunately, the topic this time is a little bit narrower. We're going to focus on the issue of rent concessions and issues associated with rent concessions, voluntary agreements and settlement agreements mostly. And additionally, we've been joined by Kelly, who I will introduce everybody in a moment, but she will discuss legislation that's been enacted that's just become law this year that is mainly from outside the Housing Committee, but still affects tenants. So Umar, I think, has handed out 3 handouts. One is a summary of legislation enacted in the last Council period 21, and then a separate list of legislation that's been introduced and pending in this Council period 22. Once again, I'll remind people, please go to the OTA website for further information about rental housing and tenant protection legislation. We have a tracking chart for both the previous and current council periods, and then we have a new FAQ on the late fee law and similar material. Also, I hope Umar gave everybody a copy of the biographies, so we'll keep the introduction short, but please refer to those to read about our illustrious panel. And before you leave, please complete a survey. Those really do help us out, so we'd really appreciate if you complete a survey before you leave. For this panel, we're going to tighten things up a bit, but each panelist will have about 5 minutes to present. And then we're going to allow for at least a half hour of Q&A, and then the time in between will be for any follow-up comments that the panelists want to make. And with that, I will introduce our panelists all at once and then let them go in order. And that order is Barry Weiss is the Legislative Director for At-Large Councilmember Anita Bonds. Kelly Hunt, Legislative Analyst for At-Large Councilmember Elisa Silverman. Shirley Edelstein is the Advisory Neighborhood Commissioner for SMD 3F02. And last but certainly not least, Beth Harrison is Supervising Attorney at Legal Aid Society of the District of Columbia. Barry.
Thank you, Joel. Looks pretty much like the same faces as in Rent Control Issues 101, so I'm not going to repeat my introduction that I had planned, figuring it'd be all new faces for Rent Control 101A, which is this session. So I'm going to go straight to a couple of bills. Well, I shouldn't just say a couple of bills, some very important bills that are on the agenda of the committee right now, which are central to the workings of rent control. And the first bill is very controversial for a host of reasons. We're calling it Bill 22-25, the Rental Housing Affordability Stabilization Amendment Act of 2017. And what this bill considers, as you all know, right now the annual rent increase that is allowed to housing providers under rent control is CPI plus 2%. And that became the law of the district back in 2006 when Councilmember Jim Graham took a look at the rapidly escalating rents and rent control housing and saw that part of the major problem of the escalating rents was just runaway annual increases. The second major problem was that at the time when an apartment became vacant, it could increase by an amount equal to the highest comparable apartment. So that law lowered it to, if there were a comparable apartment in the building, lowered it to 30% of the comparable apartment, meaning that if somebody was in an apartment for a goodly number of years and the rent was at $600 and there was another apartment identical to that one and the rent was $2,000, it could increase from the $600 to 30% of the way to the $2,000 when before it could go all the way up to the $2,000 apartment. And in buildings with lots of comparable apartments turning over time, that meant that rents just skyrocketed up all over the place. And the current law is that if it's a comparable apartment, go up 30%. If there isn't a comparable apartment, it could go up 10%. This bill limits that to 5%. And then, of course, there's controversy. I think Councilmember Bonds, my boss, hit the nail correctly. Controversy on both sides of the issue. The tenant advocates want it to be 1% or 0% when an apartment becomes vacant, and of course the housing providers want it to stay where they believe they cut a fair deal back in 2006 at 10 to 30%. The central question that the committee has to wrestle with is the evidence presented by the housing providers is at CPI plus 2%. That is what they need to have enough income to be able to afford to maintain buildings. That's the information that we hear. We have to take that information at face value unless we have other information which contradicts that information. The tenant advocates say that CPI alone is sufficient for them to maintain. The problem the committee has is we can't base information on people's opinions or people's ideas. We need to have better data and better facts on that. So that's one thing we're trying to do before we move this bill forward. One question comes to our mind. Well, actually, let me add here, one of the arguments that the housing providers also say is that CPI, the Consumer Price Index, measures a basket of goods of annual inflation in a particular area of the country. This is the Washington, D.C. metro area. But it doesn't measure those basket of goods which are relevant to the cost of maintaining a building. So what was really needed from the housing provider's point of view is that we need a CPI of housing cost maintenance, not a CPI of what the average consumer goes out when they pay their rent and get the car fixed and buy their eggs and their bread and whatever and go to a movie. So those are two different numbers. So that's another issue that we're looking into. On the third hand, we have the question of, which we're going to deal later, on rent concessions. For various reasons, there are certain buildings in certain areas of the city where the rent control allowable increases, the CPI plus 2, or if it's an elderly or a person with a disability, CPI alone, not the plus 2, and the 10% and the 30%, and the petitions have allowed certain buildings to have a legal rent increase available to them that is higher than market rate. And they can't even take it because it's higher than market rate, because you can't charge somebody more than the market will bear, which raises a terrific conundrum for those of us on the committee and for the colleagues in the room. How is it possible that rent control, what a rent that is you're allowed to charge under rent control, is higher than what the market can bear? That's the antithesis of the concept of rent control. Rent control has no value. If every rent control building in the city had an allowable rent higher than rent control, that puts a big question mark. Well, actually, there's no question mark whether rent control is succeeding, because we know the answer to that is totally failed. So it puts a question mark on what's the purpose of rent control if it's not doing anything. We're not here to answer that question, but I'm just throwing it out there. So our problem is, what is the magic number? How do we figure out what the appropriate amount is for a housing provider to be allowed to increase rent every year, which they have a constitutional right to may have a reasonable rate of return on their investment? Otherwise, we have a violation of the Constitution. It's a taking of somebody's property without just compensation. How do we calibrate that so that a housing provider gets what they need? It's certainly constitutional to have rent control. It's not constitutional if we're taking all the profit and they can't maintain the building. How do we find the magic amount of money that allows them to make a profit and still maintain some sort of affordability in the District of Columbia? We're not going to maintain the affordability in rent control at 30% AMI. That train has left the station. So these are the issues on this bill. Where is the magic number? Whether is it CPI? Is it CPI of the cost of housing? I don't have the answers right now, but what I'm sharing with everyone here, this is the problem that we're wrestling with, is we can't have buildings that have rent control that is way above what market. We can't have buildings that have rents that are so outrageously high that you folks can't afford to live them anymore. But we also can't have a number so low that we've violated the U.S. Constitution and did a regulatory taking of the property of a housing provider. So that's what we're wrestling with. We're going to rely upon people that we work with to help us come up with numbers and try to see what's fair so that we satisfy all these issues. And that's, have I used up all my time on that one bill?
And more.
And more, okay.
Did you put into my time?
I cede my time to my colleague on the left, any remaining time.
Good afternoon. Everybody have their caffeine ready to go? Right. Well, so the bills that I'm going to be talking about largely have been introduced, but are still in various stages of the process. A couple have been passed, and some were funded through the most recent, through the FY18 budget. So starting there, and all of the bills that I'm going to be talking about either were introduced by my boss or were introduced through other committees, but still impact the housing arena. So the first one is the Expanding Access to Justice Act that was introduced by Councilmember Allen through the Judiciary Committee. So everyone knows that, or if you're watching Law and Order, you know, that if you commit a crime and can't afford an attorney, one will be appointed for you for your charge. That's not the case for civil issues. We also know that housing eviction costs everyone a lot more than just the cost of someone having to find a new place to live and housing provider having to find a new renter, right? There are exponential costs associated with that, both to the housing provider and to the renter. So Councilmember Allen's idea was that we need housing legal assistance for people who are in the eviction or going through eviction or being evicted from their homes. And so the service that would be provided is that when you go to the landlord-tenant court, the person who's being evicted would have counsel appointed to them, so they will know their rights and can defend them in the housing eviction court. This was introduced late last year and then reintroduced earlier this year. Fortunately, there are ways that we can not have to go through the normal process of having a hearing and passing the bill when it's a great idea. We can just put it into the budget. So it still gets a full hearing, the information is all shared, but it tends to move just a little faster. So we do actually have money in the FY18 budget. So if you're going through eviction, then you will automatically be assigned an attorney that can help you with that. With the idea being, hopefully, everyone wins if the eviction is prevented. If it's, funds that you need, we have the Emergency Rental Assistance Program. The housing provider wins because they don't have to turn around and release the unit. Person gets to stay stable and stay in their unit. So that was the first one that just was funded through our budget, and so it's enacted in law. Now we'll see going forward how well that works, and we'll likely be tweaking it in the coming years depending on usage of the program and how hopefully effective it is. Coupled with that, my boss introduced a couple of bills, the Displacement Prevention Amendment Act of 2017 and the Displacement Prevention Assistance Fund Establishment Act of 2017. We try to make these titles as long as possible so that you won't remember what they are. My boss is of the opinion that when the district makes a significant investment in redevelopment in a community, the people who have been living in that community or in that neighborhood should be the first to benefit from that district investment. Unfortunately, that is not the case. A Washington Post poll last year shows especially people of color tend to find that they are not the recipients of district investment in communities. So specifically in talking about the Congress Heights redevelopment, the St. Elizabeth's redevelopment, the Wizards practice facility is what it is. She introduced these two bills specifically as a pilot for that community that would provide them with, again, legal assistance for people who are being pushed out, but also an increase in the Schedule H tax credit that both renters and homeowners can take advantage of. Just real quickly, just for my own edification, does everybody here know what the Schedule H tax credit is? See, I would say we need to promote that more because it can benefit a lot of people. But the idea there is that you get both the benefit of increased income through the tax credit and also legal assistance if you're being unfairly pushed out of the neighborhood as it goes through redevelopment. Unfortunately, we weren't able to get any funding in the FY18 budget for those two causes. Most people felt that the expanding access to justice funding kind of covered that, but we are going to still be pushing forward this coming year to try and get those two things, get hearings on them and get those through. The redevelopment is still taking place, so we really would like to see that the people who have been living in that community for a long time get to stay there if they want to. The next one that I have is the short-term rental regulation bill. Now, that's what everybody's calling the Airbnb, VRBO, home away bill, short-term rentals. The idea is to better regulate the expansion of the short-term rentals. DCRA has not been able to keep up with the very rapid expansion of usage of short-term rentals, and so we're trying to find a fair structure so that the people who both host short-term rentals and the people who use them can do so to restrict the type of things that were actively hurting our affordable housing or contributing to our affordable housing crisis. Using as an example, a building owner in Ward 1 was found to have essentially completely turned his rent control building into an Airbnb, or I'm sorry, I don't even know if it was Airbnb, a short-term rental facility, actively avoiding both rent control and TOPA. So that's the kind of thing that we want to stop. The bill has been introduced and had a hearing. I've spoken with people in the last week, and essentially they're still working out the details on a compromise, on hopefully a global bill that will benefit / irritate everyone, right? So when you come to the compromise, there are going to be people angry on both sides, right? We are not going to be marking up that bill in the next month anyway. Essentially what I've been told is that the council members and staff will get a briefing probably a week before the bill actually goes to markup. So hopefully we'll all have time to read it and then be appropriately outraged at whatever piece of it that we don't like. The Inclusionary Zoning Consistency Amendment Act. So we have an inclusionary zoning program in the district that requires all new developments to have set aside a certain number of its new units for people at certain income levels. This is both for rental and home ownership. We found that some of the income targets were not really helping the people that we wanted to. So for the last year and a half or so, the Zoning Commission has been studying this with the help of both district government and advocates, and came to a settlement so that now going forward, all of the rental units will be set aside for people at 60% of the AMI, and all homeownership units will be for people at 80% of the AMI, and that actually we're passing the congressional review temporary on Tuesday. So that is in place. DHCD has issued the regulations, and so hopefully we're going to get a whole lot of new IZ units that we need. The drug-related nuisance abatement amendment. You heard at lunch a little bit from Carl Racine about his office actively going against housing providers that are not taking care of their buildings. This actually was a bill from Councilmembers McDuffie and Evans in conjunction with OAG Racine's efforts to help better take care of the properties and some of the things that have kind of been allowed to go on in certain neighborhoods. It essentially gives the Attorney General expanded powers to go after people who are allowing active drug trade on their properties. The Property Disposition Reform Amendment Act, that's one that my boss introduced, and it set more than a few people's hair on fire. And in all honesty, it was kind of intended to. DHCD owns upwards of 150 vacant and blighted properties, and that's both outrageous and unacceptable. And before everybody starts tweeting, we're not calling DHCD outrageous and unacceptable, but this particular problem, the issue is a real problem. And there are many things that they do very, very well. We're just recognized nationally for having done that. Their pad division really needs some work, and we can hold two thoughts in our head that we love some things that we do, but they really need to take care of this issue. Have owned some of these properties. Is it a legacy? This isn't a legacy issue. Some of these properties they have, DHCD has had in its portfolio for decades. So our idea was, if we can get a hearing, we tossed out an idea of handle it the way HUD has in some regions, and basically let the realtors take over, get a contract essentially with the district government to sell these properties. Now, it was not our idea for them to just sell them wholesale. There would be restrictions. They need to go to affordable housing, either low-income owners or developers who would turn around. I mean, none of these properties are frankly in condition to occupy at this time, which is another reason that it's outrageous. If these properties were owned by private owners, they would be taxed at the vacant and blighted property tax rate. Since the district government, they don't have to do that. And we shouldn't expect things of private citizens that we don't expect of ourselves. So our idea was, okay, what you're doing is not working. Here's an idea. Why don't we have a hearing? We'll toss out our idea. You guys can come tell us why it doesn't work, but maybe through this process we come up with a workable solution that actually gets us to a position where these 150 units are actually back in production. We have this affordable housing crisis that we're always talking about, so we have 150 units here that we could house people with. So let's move forward with a plan for that. So we have not yet scheduled a hearing on this particular issue. If you are interested in this, you might consider contacting the committee office to see if they will schedule a hearing on our bill. No.
Barry is not taking the
Barry
hands.
is not
Sorry.
taking questions at this time, so.
But thank you, Barry, and thank you, Kelly. And Shirley is now going to start our pivot to our main topic, which
Okay.
is rent concessions.
I'll move this over so Beth can use it too. Hi, everyone. My name is Shirley Adelstein. I'm the Advisory Neighborhood Commissioner representing Single-Member District 3F2 in Forest Hills. I would like to provide a little bit of background and perspective on the experience of rent concessions. I became involved in this issue because one of the buildings in my district, which I also happen to live in, is 3003 Van Ness. We are a rent-controlled building, and I began hearing from a lot of folks about their experiences with so-called rent concessions. These are essentially abuses of the goal of rent control, which is to stabilize rents, which has had precisely the opposite effect. So I know we're short on time, but I'll just briefly describe for those who don't know the issue well what it is that's been happening. And then I know Beth will talk a little bit more about the legislative process that's been in the works, but I would like to say something about the advocacy process because I think it is helpful in thinking about how a variety of issues can be brought to light and action taken on them. So in brief, what's been going on with rent concessions is that, as we discussed, a rent-controlled unit is limited in terms of the amount that a landlord can increase the rent every year, 2% plus CPI or just CPI for certain residents. What's been happening is that some landlords are filing the maximum possible increase every year with the city. They're required to file the rent charge with the city, but they're filing the maximum every year. And over time, this has led to the amount that's written on paper being quite high, much higher than market. So when people go to actually rent their apartments, they're offered a concession or a discount. And let's say the number on paper is $2,000. If you applied the maximum increase every year, we'll give you a $1,000 so-called concession, and you'll only pay $1,000. But then when the next year comes around, they want to raise the rent by applying the maximum increase to the pre-discounted number. So in effect, that results in a number that is potentially, and in practice often is, much higher than what is actually allowed by law. So what does this do? I can tell you because I live in this community and I talk to a lot of people since I started working on this issue. Many other people from many other buildings throughout Ward 3 and also elsewhere have come to me to say that this not only undermines the very purpose of rent control to stabilize rents, it's actually generating tremendous financial strain for people, tremendous stress, and in the worst cases, and unfortunately I'm seeing quite a few of them, people are actually being forced out of their homes. So this is really undermining the basic premise of rent control. So what I think is interesting too is just reflecting a little bit on the process from understanding these issues to how we got here now from an advocacy perspective. I know many of you are dealing with issues yourself, and now we're on the cusp, I think, of some actual legislative action on this. I can say that there has been a multi-pronged approach. Tenant associations are very important. The leader of our tenant association has been very active on this. The ANC has been very active on this. ANCs have very important roles to play in being a voice for the community. So if you're dealing with issues like this, going to your ANC can be a very, very valuable vehicle for bringing a larger voice to this. And we've worked together in partnership with city council members like Councilmember Che and Councilmember Bonds, who believe deeply in tenants' rights. And together, by leveraging all of those voices, we've managed to begin to move forward a legislative agenda that will actually resolve this problem, we hope. And I'll stop there because I think Beth will talk a little bit more about how we're hoping to do that.
All right. So Shirley did a great job of laying out that issue. So rent concessions, it might seem like, why would a rent concession be a bad thing, right? The landlord's charging me less than the landlord can. That's great for me as a tenant. And so I can share some experiences I've seen of what happens to tenants sometimes in these buildings. So a colleague and I worked with a building that was 75 units, where a hardship petition had been done. We talked about that in the last session. And so they had gotten a large conditional rent increase, but they weren't charging it to everyone. But what they said to the tenants is, we won't charge it to you if you're a good tenant. But if you're a bad tenant, then we reserve the right to immediately take the rent increase. So make sure that you pay your rent on time, make sure that you don't violate your lease, and you do everything that good tenants are supposed to do. And hopefully many of you know that the laws in DC really protect tenants who are facing eviction where the landlord says that they are doing something wrong, that they are paying their rent late or they're violating their lease, and they have a chance to fix the problem, and the landlord has to give them notice and so on. But this landlord saw, I can use this and just say to the tenants, you have to be good, I'm watching you, or I'm going to take the rent increase. So one thing that we have talked about in a bill is making sure if you offer a concession to a tenant, if you offer a discount, it needs to be unconditional, meaning it can't be taken away just because. And it also needs to be for the lifetime of the tenancy. So as long as you're in the building, you're going to get that lower rent amount. And that really protects tenants from having the landlord kind of hold it over their head. So that's one thing that's really important. And then the other thing that's happening, Shirley was talking about folks moving out, and so the tenant who has a $2,000 rent on paper, but is only being charged $1,000 under rent control, they would have a pretty low rent increase every year unless the housing provider files a petition and gets approved by the government for something larger. Some landlords are going to these tenants and demanding, if you're going to stay, you have to pay a $200 rent increase, a $300 rent increase, a $400 rent increase. And that's very stressful. It causes folks to leave. It may cause tenants to agree to a higher rent increase even than what the market would allow, because it's really a pain, it's a pain in the butt to move. Nobody wants to move, right? And so we want to make sure, if we have legislation, that rent increases will be based on that lower amount. It will be based on whatever the landlord is actually charging. And then we also want to make sure that there is transparency when units are being advertised. And so it can be very confusing if you're moving into one of these buildings and the landlord, some landlords may say something kind of like, on paper it's $2,000, don't worry about it. I'm only charging you $1,000 a month. So we want to make sure that when buildings are being advertised, tenants will know It would be great if things have to be filed with the government. It would be great if things are in writing between the landlord and tenant, just so it's a very transparent process about what's going on. And I think I will stop there.
Okay, great. Well, I'm going to ask maybe one or two questions. We'll see how this goes. There's been, as Barry alluded to, I think, a working group over the past year that's been discussing the issue of rent concessions and how to resolve it, building on the introduction of legislation by Mary Che just after last year's summit. And a part of that discussion has involved the notion of a so-called good rent concession. And our lawyers here have alluded to the unlawfulness, the illegality of these practices. And OTA completely shares that position, of course. But the fact is, rent concessions is not mentioned in the law. What makes it illegal is that they're walking and talking and acting like a de facto rent ceiling. And the council abolished rent ceilings back in 2006. So the good rent concession notion is that there is such a thing as a rent concession that does not walk and talk like a de facto rent ceiling. And Barry, can you just speak to that in terms of the committee's consideration and the working group's consideration of that issue, and just whatever comments you want to make about that?
Oh, just that lowering of rent can be for all sorts of reasons. They can be for nefarious reasons, or they can be out of the kindness of somebody's heart. Those type of good concessions that we're talking about usually, but not necessarily always, occur in a smaller building where everybody knows everybody. And you might have a circumstance in say a 10-unit building where the owner actually lives in the building and they know somebody for a couple of years, and that person broke their hip or lost their job or for whatever reason are in a financial situation, and that housing provider has the capability and the inclination to say to them, you know what, for the next 6 months, your rent, I'm going to lower your rent by 25%. Can you handle that? And that's what we call a good rent concession. When we're looking at this issue, we don't want to make the mistake of when we outlaw the ones that were discussed previously, we inadvertently also outlaw a good concession that helps somebody out when they're in need. We don't want to, as Mary Che said last time, when she sat down right here, she said, we don't want to throw the baby out with rent concession bathwater. So that's the concept, and that's what we're wrestling with, is that we deal with this in a way that allows the best to happen, and we prevent this other types of situations which put people in a terrible financial stress, makes them worried about having to move, makes them worried about having to find another apartment, which as y'all know is really hard in DC. Maybe they'll be forced to move out of DC, and that's the last thing we want. We want people to come to DC, not to move out of DC. So there's a lot of very complex issues that we're wrestling with this with the ultimate goal of keeping DC as affordable as possible so the widest diversity can continue or can be enhanced in the widest diversity of people and cultures and economics and societies, et cetera, can be enhanced in Washington, D.C. That's the bottom line. I know for my boss, I know for Kelly's boss, I know for Councilmember Che, and I'm going to dare go out on a limb here, the other 10 council members.
So I'm going to ask another question. But in the meantime, if you have a question, would you please line up behind the mic? And my question is primarily, and that being the case, I'm going to ask a short question and ask for a short answer. But I think it's important that we have Beth in particular discuss the rent concession issue in the context of voluntary and settlement agreements.
Sure. So if you were at the panel before, Rob Wool from LADC was talking about this a little bit. I'm going to go back to my 75-unit building that I love. So the housing provider there had filed a hardship petition, and then actually the ownership of the building changed, and they filed a second hardship petition. And this happens, a fair amount. It happens in voluntary agreements or in settlements of petitions. So the landlord comes to the tenants and says, I have the deal of a lifetime for you. You're going to agree to the rent increase, and you're going to agree to both hardship petitions, even though a judge would never grant both. They would only grant one. And you're never going to have to pay it. It will apply to tenants who move in after. We'll go ahead and take the rent increase on paper, and this is where the rent concession comes in. You'll get a rent concession, so you won't have to pay it. But as you move out, your neighbors who move in will be paying that higher rent. The tenant association I was working with agreed to that, but they knew in agreeing to it that it's going to completely change their building. And they were not happy about that, but they were facing, if we fought out, the case that had been filed against them, they were going to get a rent increase, probably. It might have been 20%, 30%. And so instead, they agreed to over 100% rent increase on that building. The rents more than doubled for those units. And it's in a gentrifying area, and it's going to completely change that building over time. I'm really glad the tenants I worked with, who were great folks, who have been in the district for years, had been in that building for years, are hardworking, tenants that we want to keep in the district. I'm glad they get to say, but it kind of made me sick to my stomach what was going to happen to that building. And the rent concessions, this is kind of an example of what I would call a bad rent concession. It's being used to essentially turn a building that's affordable into an unaffordable building over time. So and that can happen with voluntary agreements too. So they will have, a landlord will say to a tenant association, a group of tenants, agree to a voluntary agreement, we're gonna double the rent, but you're never gonna have to pay it. And so as a tenant, you can imagine, how you feel in agreeing to that, but it's really harming affordability across the district.
And thank you, Beth. And I'll just quickly mention that Bill 22-100 has been introduced by Councilmember Bonds and Shea and Silverman, and both council members White, called the Preservation of Affordable Rent Control Housing Amendment Act of 2017, which deals with this issue very narrowly to prohibit agreements, specifically voluntary agreements and settlement agreements, from doing that cost-shifting maneuver to have tenants basically get special protections in terms of rent increases for themselves, but then basically moves those buildings out of meaningful rent control for all future tenants. It does not solve the problem of voluntary agreements at all, because all the other problems remain to be resolved by the Housing Committee, presumably, in upcoming legislation. And it doesn't solve the problem of settlement agreements either in other contexts, but just on this narrow issue. So thanks for the presentations, panelists. And first question, Ms. Grimstead.
Hi, I want to comment on the last bill in the handout, Property Manager Licensing Amendment Act of 2017. I wanted to share with you what happened when I ratted on my property manager because I knew during her 4-year tenure that she knew nothing about anything about DC law for tenants. She wasn't from here. Her employer is Graystar, and they're from South Carolina and just new to the DC area. So I just want folks to know that turning somebody in for not being licensed is not for the faint of heart, because you bounce around between DCRA and DHCD as to who's supposed to do something. And then finally, they figured it out, and they notified me that they contacted her, and she wanted a waiver. And I immediately said, oh, what grounds? Her title is property manager. It says it on the business card. I'd given them 20 notices to tenants saying property manager. What? She was, or Graystar rather, was fined at $2,000, and I had to do a FOIA request in order to be able to see that she was indeed fined the $2,000. The notion that somebody has to have some pre-licensure education requirements, good idea, because I think people can get away with just doing a really quick study on the rules and then take the exam and pass the exam without really having the background knowledge that you should. Where I've lived for 10 years, Aventine, Fort Totten, it's been a matter of pick your battles. So ratting her out wasn't the first thing on my list to do, but I finally got around to do it, and I'm so glad I did. And if Councilmember Bonds has any influence with DCRA, I think whether or not the property manager is licensed should be something on the checklist for that proactive every 5-year inspection. Just because I believe there's particularly in large complexes, there's a whole, that are managed by out-of-state, whatever, there's a whole lot of property managers that aren't licensed. Too bad there's not a whistleblower fee associated with that. Thank you.
Where did the $2,000 get placed? The fine?
The fine, $2,000?
Yeah, and they paid it to whom?
I would have thought the DC government. I didn't pay attention to the fine print on the check, but that's not, I knew it was not monies coming to the tenant. That
No,
is
I was just curious if it went
a penalty
to,
going to
if
the
it went
DC
to rental
government.
housing or something like that.
And if they didn't pay it, DCRA would take them to OAH, presumably, to pay the fine, I think. You said you don't know if they paid it, is that right?
Yes, I do know they pay the
They
fine.
do? Oh, they
I
did
don't
pay
know
it.
what DC budget bucket the monies were applied
Okay, I know, I'll look into that, thank you.
OTA would be nice, but
Just,
Yeah.
just to be clear, you're in favor of Bill 22-396? Okay.
more.
Yes.
And get DCRA to pay attention.
Wonderful, thank you. Great question. Christopher,
Yes.
you're up.
She brought up a good point that I forgot, but I had 3 things. One is property managers. There was a situation in my building where the manager always said, well, we know what we're doing. We correct it. But then I had to call them back and say, hey, the problem is still there. So they send up an unqualified cleaner who's supposed to be a licensed maintenance person. Oh, we'll send up so-and-so. She's licensed. So when they come up, I get the word, oh, I'm sorry, she's not licensed to do the work in the district. And that really gets me because they tell you one thing, they tell you another. I had to go to court because of a situation of which you're aware of. And on the DCRA webpage, there is a link to what they call VUE, V-U-E, which shows the licenses of the various professions. One of it is housing. And I checked the individuals that were supposed to be qualified and took the test, nothing was there. So that got brought up in court, and then all of a sudden I find out that the umbrella management company got a license, and everybody in the staff got a license. Now, they're supposed to take a test. What did they do? What was the test? $35 you pay for a license. And within that structure, if you manage 3 buildings, you have to purchase 3 licenses. You do not make a Xerox copy and place it in the 3 places. Also, the thing is, if you leave that property, you return it to the appropriate jurisdiction. The other thing I noticed was that the umbrella company, they reduced it in half and placed it with the other certification. That covers the property managers. The other thing is the rent increases. 30 days, I do not feel is sufficient for a housing provider to notify. That should be moved up to 45 because that gives them a little wiggle room in those 15 days to ensure that the individual gets the form.
Okay, great. Well,
And-
those are great points, Chris. I want to
Yeah.
move on. We're spending it's a very important issue, and there are current violations. There's the legislation to require further training for property managers. And those are all important issues. There's the ability of DCRA as of now to kind of inspect for the presence of a copy of the license as required by the regulations. And how and when that gets done is a question. There's maybe a bit of an enforcement gap simply because it's a challenge for DCRA to do. But that's as important as a set of issues as those are. I think we need to move on to another question and maybe a different topic. Ms. Lee.
My question has to do with addendums to a lease that we have to sign that was dated to come into effect June 1st of this year, and I just got it yesterday afternoon, and it said we were supposed to have been notified like 30 days before, which would have been like the 1st of May, and I remember this has to do with smoking, making our senior building no smoking, which I would really love because I have allergies to smoke and stuff. But I remember asking back in May, our receptionist in the office, in the rental office, about if she thought the no smoking thing was going to come in, and nobody thought it was. So now I just get this thing yesterday that I have to sign as an addendum to my lease. And there's a bunch of other stuff on it. There's like 4 or 5 things. But to me, that's the most important thing. And the other thing was loitering. I know DC does not have a loitering ordinance. And can personal property, can they do their own loitering? I mean, it's pretty, I'd like to have some of you guys look at it.
Right. I think, Barry, can you speak to that just in terms of the issue you just raised, you just mentioned? I'm putting you on the spot.
I'm going to defer to some of my colleagues on the far left there. I seem to remember that loitering laws are unconstitutional, but I'm sure you
Yeah. Well, there's a difference between the government saying you can't loiter and then a house rule potentially. But Beth, can you speak to that?
Yes, sure.
Sorry to put some...
No. I mean, I'll give the other perspective, which is I understand there are 2 sides to this issue. Loitering is such a vague word. What does it mean to loiter, right? And so as an attorney who represents tenants who are often facing eviction, and often landlords, or too often, I will say, landlords are trying to evict a tenant for some other reason. They don't like the tenant's a pain in the butt, they want to clear the building for some other reason, they want to raise the rent. Being able to evict a tenant for loitering, is just, it really kind of opens the door to bad practices by landlords. So yes, there is an argument that it's unconstitutional, it's vague. We always hate that when we see landlords kind of going after tenants and saying they're loitering for that reason. That's not to say that there aren't sometimes problems with, kind of folks hanging around and disturbing sometimes other tenants. Right. It can be an issue. But that's the other perspective on it.
Okay, but can somebody, I have the documents with me, can somebody look at it? Or do you want me to come in the office?
Yeah, please come to the office and we might consult some of our very capable legal service provider attorneys as well.
Okay, I don't know when I have to sign it by. I just got it yesterday. So.
Okay.
Thank you.
Hello, thank you for taking the question. I am the president of my tenants association, and I have many residents coming to me about rent concessions.
What building? Can you say what building?
I did not. It's the Rittenhouse Tenants Association, which we all, of course, know about the how we are in court on our TOPO process right now. My name is James Spinella. You can read the articles in the Northwest Current. Hello, Scott. But going back to the topic of rent concessions, Greystar, who we've already heard about before, in the past 2 years has implemented or brought these rent concessions into the building. And I know, Beth, you said there is current or proposed legislation so that the rent concession is for the duration, as long as the person stays in their unit. We have been told, and residents have been told, as long as you come back every year and refile with us, then you can maintain that concession. That's what they were told a year or two ago, right, when they signed their lease. What's happening now is they're getting tricked. We'll sign a new lease, and we'll go ahead and that $300 concession, you can maintain $200 of it.
Right.
You know, things like this. So the question is, what does the current law say, as I'm trying to assist them, right? What kind of leverage do we have to refile or renegotiate this paperwork every year to maintain that concession of what they were verbally promised when, you know, that they signed their lease a year or two ago?
We can have Beth speak to the, if Beth wants to, but we can have, can you speak? So we're going to have Beth, I'm sorry, we're going to have Barry, first of all, in terms of the current law, it's been the OTA's position and the position of many of the tenant attorneys that to the extent that the concession is acting like a de facto rent ceiling, that's the nub of the issue, then it's unlawful under the existing law. It's a big gray area because, again, rent concessions is not a term mentioned in the 2006 reform of the rent control law that abolished rent ceilings. So I'll just the argument needs to be made in terms of legislative intent. The fundamental principle is that, you know, an end run of the law is a violation of the law. So that's the argument, kind of broad brush, as to why it's currently illegal. But Barry is going to speak to so there's an ongoing working group trying to resolve the issue to clarify, not amend, but to clarify why rent concessions and when and where rent concessions violates the current law and when it might be acceptable. And Beth, do you want to speak to that?
I mean, that's basically what I would say, is
Okay.
there are a lot of places where the law is not clear, right?
Yeah.
And so I think in rent control and everywhere else, when we see that the law is not clear, then we are going back to the council and asking the council, make this clear. So I completely agree with Joel. That's our position as well, or my personal position. But we really need legislation so that it is clear that landlords cannot do this, or if they can, that there are strict limits on it, so tenants
Right,
like you are
I was glad to
protected.
hear that legislation had been proposed. But what I'm hearing then right now today, if on Monday next week I need to go in and help somebody renegotiate their rent, right?
Mhm.
I just have basically this verbal promise from before and acknowledging that there's this gray area of the law, and it's going to be the least.
Let me just say this. There are attorneys, not just OTA attorneys, who are drafting tenant petitions, but there are private attorneys out there who are filing challenges to rent concession, that second year increase based on a rent concession or reduced or eliminated rent concession in court, basically in the arguments that Beth and I are talking about. But would you come to the OTA and talk to us?
Sure. Yep.
Or we can talk afterwards. What I'd like to do, I've been given the signal to wrap up. So, but I would like to get Ms. Glickstein and Tom Gregory's comment or question.
Quick comment.
Very briefly, and then, but together, and then we'll let the panelists respond very briefly as well. But Barry, you want to say
Just one
something
thing.
quickly?
We're expecting decisions from the Rental Housing Commission on these kinds of issues any day now.
Okay.
So if you can wait a week or 2 weeks before they go in there, maybe there'll be a decision and it'll guide what you do.
Okay.
Ms.
My question kind of actually feeds off of his, so it can be real short. My understanding under my rent concession is if I get run over by a truck or otherwise break the lease, that the remainder of the rent is due in full and it's at the higher level. Is anything being done with the proposed legislation to address that so that my estate doesn't get stuck with the higher bill? Did I not explain that well? You have this look on your face like, huh?
No,
Okay.
I think it's the same answer that was just
Okay.
given you. The law is gray there, but if the Rental Housing Commission decision comes down in the way that we're hoping,
Yeah.
then that would be nonsense.
Okay.
I mean, the question about an estate just raises a lot of other legal issues, and I'm not a probate attorney and don't
Okay, I
pretend to
didn't
be a
mean to
probate
muddy
attorney.
it,
But yeah, I think
It
in
is
general
in
on
my
rent
lease.
concessions.
Yeah, okay. All right, thank you.
I just want to say one thing because I can see that there are other people in this audience who are experiencing the same things we have experienced in my district, and I just want to implore you to reach out to your local community leaders and let your ANCs know this is happening. We have last year, ANC 3F passed a resolution weighing in on this issue, the initial bill that was passed, which is under modification. We need the help of other ANCs to elevate this and make it an even bigger priority than it is. If anyone would like to talk about that, please see me after.
This is really short. Joanna Shreve continually has advised us through the years that the plus 2% was a temporary experiment and should lapse and be if there was sufficient reason to continue it, then so, but otherwise should not be continued. I personally think that while a lot of the issues we've been working on today are very important to individual smaller groups, the plus 2% applies to everybody under rent control. And so it should be a top priority. As I understand, AOBA now has maneuvered very cleverly so that instead of the responsibility for proof being on them to show why the plus 2% is appropriate, now they've got to convince people to reverse that, and now we, the renters, have to prove that the plus 2% is not correct. Then I'd like a little clarification.
No,
But
I
let me
didn't-
add one other thing. What makes this seem so ridiculous is here the landlords were saying, no, we're not going to show you our income tax returns. We're not going to show you how little profit we're making, but you've got to find that out before you can prove that the plus 2% should be discontinued.
Okay,
I'm
great.
sorry, Barry.
So, and Barry, you have 30 seconds to
Okay,
solve
in
all
30
of that,
seconds.
and then we wrap up.
I'm sorry if I didn't make myself clear when we spoke before. Since Councilmember Bonds has introduced a bill to change the law from CPI plus 2% to CPI alone, the burden is upon her, since she's the one who is a proponent of the change, to prove that CPI alone is the appropriate amount rather than CPI plus 2.
Okay, then that leads to my,
If it were the opposite, if the housing providers were introducing a bill that said CPI plus 4 is the appropriate amount, then the burden would be on them. That's all I meant.
okay, then
The
if I
proponent
understand,
of the change has the burden to prove the change makes sense.
but
Tom, I'm afraid we do have to leave it there, but I understand the point you're making. And
10
that-
seconds? 10 seconds.
Yes.
My question I was leading to is, what research group would, in brainstorming, if you like, what research group could find out the information that allow that decision?
I think that's essentially the question that Barry was asking when he made that comment. So, but let's talk about,
I don't know if the Hudson
possibilities.
Institute or whatever groups that have
Right.
done research before on
Right.
some of the housing issues.
Absolutely.
But it sounds like we need some group working on it.
There is a need for more data on both sides. Both sides say
Amen.
that about the other side. So please do complete a survey and before you leave, and hand it to Umar, who I think is somewhere here or near. And please help me thank and thank you again to all of the familiar faces here who really have done some great work at the council in helping get this legislation enacted. And please help me thank the panelists.